the Companies Amendment Act largely seek to be pro-business or pro-enterprise. And we can see this in some of the changes in the Act. For instance, there is now an audit exemption for small companies. The current provision states that private companies with annual revenue of $5 million or less are exempt from having their accounts audited. But the Amendment Act expands the category of exempted companies to include a concept of small companies. And that's a private company which meets at least 2 out of the 3 criteria, namely whether its total revenue, annual revenue is less than $10 million, its total assets is less than $10 million, or the number of employees are not more than 50. They are still required to keep proper accounts even if the exemption applies. So this would be something that would be welcome by small or medium enterprises even. Another pro-business amendment would be the removal of the one share, one vote restriction for public companies. The Amendment Act allows public companies to issue shares with different voting rights, for instance, special rights or limited rights, and this gives flexibility for companies in raising capital. So I think this would be welcome. Another amendment replaces the concept of memorandum and articles of association with the new concept of a constitution. The net effect is that private companies and companies limited by guarantee may choose to adopt the whole or certain parts of certain model constitutions prescribed for different types of businesses. And companies, of course, can opt to include additional provisions to the model constitutions. Another recommendation is in relation to ACRA, the company regulator, if you like, to maintain the register of members for private companies. The current requirement is that private companies are required to keep their own register of members. Under the Amendment Act, ACRA will maintain the register of members of private companies, and all share transfers and changes in share ownership will have to be registered with ACRA. Next, in relation to statutory disclosures, under the current Companies Act, only directors are required to disclose conflicts of interest in transactions or shareholdings in the company and related corporations. The Amendment Act extends this concept to the CEO of the companies. This is to obviously strengthen corporate governance. And also in acknowledgement that increasingly the CEO plays a very important role in company decisions. The whole intent of the changes to the financial assistance provisions is really to help private companies such that they do not have to go through time-consuming whitewash procedures. So this is really a business-friendly approach. And although the existing financial assistance prohibitions will no longer apply to private companies, I think it is fair to say that they are not able to freely provide funding to a purchaser of its shares. Directors will always have fiduciary duties, so they should be conscious of that. And they could potentially breach their duties where transactions that provide no commercial benefit to the company or are deemed to be detrimental to the company or against the interests of the creditors or shareholders of the companies. So those fiduciary duties remain. In particular, directors of private companies should also be mindful of the following. One, that financial assistance should be given for a commercial purpose in the context of a transaction that the board of directors reasonably believes to be for the company's benefit. So that's one. And second, that the assistance should not materially affect the company's abilities to meet its debts and does not materially deplete the company's assets. Here, a public company and its subsidiaries will be allowed to acquire shares in the company or holding company so long as it does not materially prejudice 2 things. One, the interest of the company and its shareholders, and second, the ability to pay its creditors. So the board of directors must also pass a resolution stating that the company should in fact give the assistance, that the terms of the assistance are indeed fair and reasonable, and the grounds for their conclusion. Directors will also need to determine whether there is material prejudice to the interests of the company, and whether the terms and conditions of the proposed financial assistance are fair and reasonable. And the amendments actually make clear that certain transactions are excluded from financial assistance prohibition.